Thank you. So welcome everybody to our seminar this morning on the Corporate Transparency Act. We will be discussing today these new entity filing obligations. I am Amy Ebling, an attorney with Reuter Ware. I practice in the business transactions area, doing mergers and acquisitions, succession planning with a focus on tax reporting or tax work. And I'll ask my colleagues, Jake and Lucas, to introduce themselves.
Hi, everyone. My name is Jake Schrader. I am also an attorney at Reuter Ware, and I am also in the business transactions group here.
And I'm Lucas Sigalski. I'm also in the business transactions group. And along with Jake, I spend time helping clients comply with the CTA, doing the filing. So
Great. Thank you, gentlemen. So let's get started. First, I want to just make an announcement that today's presentation is to provide information of a general nature about the Corporate Transparency Act, otherwise known as CTA. This is not legal advice. And just to be clear, this is a new piece of legislation, and so things are evolving and changing. So the information shared today is as of today, May 22nd, and certainly there may be changes forthcoming. So to get started, I just want to provide you with a very broad agenda for today's presentation. We're going to go through understanding the CTA and the key provisions and definitions, as well as provide some practical steps for compliance with CTA. We're going to talk about the current legal landscape and those legal challenges and potential changes that may be forthcoming, as well as provide you with some contact information in the event you need some additional guidance or need assistance with your CTA obligations. So to start, we're going to go through understanding the CTA. We're going to provide an overview of the Act and then key provisions and requirements, including the definitions and exemptions. So let's get started. First is understanding the Corporate Transparency Act, an overview. So CTA was enacted as a part of the National Defense Authorization Act for the fiscal year of 2021. So we've had this piece of law around for the last several years. However, the effective date was continuously delayed until recently. It went into effect on January 1, 2024. The primary purpose asserted by the federal government was to combat money laundering and terrorism financing and other illegal activities conducted by anonymous shell companies. A quick summary of the law is that essentially CTA requires entities to report information about beneficial owners, and that is a defined term. And you're going to learn here this morning that is more than just an owner. But it requires information about those beneficial owners to be reported to the Financial Crimes Enforcement Network. You'll hear us refer to that as FinCEN, which is a part of the U.S. Department of Treasury. And the government's goal with this piece of legislation is to create transparency and make it more difficult for individuals to use those anonymous entities to conduct illegal activities. As I said, this is a new piece of legislation enacted in 21, but just became effective January 1, 2024. So there is very limited guidance available on this new piece of legislation. FinCEN has issued FAQs and does provide some guidance on their website, but we do not have case law or other rulings that normally lawyers rely on to provide assistance with interpreting the statute. Additionally, there have been lots of nuances or questions that have come up during this first quarter, first 5 months, 4.5 months of compliance. And those questions have been proposed to FinCEN, but we don't have necessarily responses or answers. I do also want to mention that as a result of this piece of legislation being so new, there are very few people providing guidance or assisting with filing. So I just encourage you to try to learn everything you can to ensure that you can comply and seek out assistance if you need any. All right, let's get through some of the key provisions to start. We're going to talk about reporting obligations, the exemptions to the CTA, the definition of beneficial ownership, which, as I said before, is more than just owners, so it's a little bit misnamed there, and then penalties for noncompliance. So I'm going to turn it over to my colleague Lucas to start talking about these key provisions.
Thank you, Amy. So there is a presumption that entities that qualify as a reporting company have to file under the Corporate Transparency Act. Reporting companies are entities created by filing something with either the Secretary of State of a state, or in the case of Wisconsin, the Department of Financial Institutions. Reporting companies also include foreign companies that are registered to do business in the United States. Here's a list of some of the entities that presumptively have a reporting obligation under the CTA. Just to be unambiguous, people typically assume that some people assume that this only applies to companies that are in a business, but it also includes LLCs and corporations and other kinds of entities set up to hold, for example, family cabins, cottages, hunting shacks, investments, real estate investments. It's not limited to just businesses. It's any entity that is created by filing something with, in the case of Wisconsin, the DFI. For each reporting company that has to file, you file a report that includes the following information. Number one, information on the entity. So that would be the legal name of the entity, the entity's EIN, the principal address, and some other elementary information about that entity. The entity also has to file information on its beneficial ownership. And we'll talk about this in greater detail later in the presentation. But for each beneficial owner, including things like the full name, the date of birth, current residential address, and that has to be updated, just like all the other information when it changes, and a unique identifying number from either a passport, a driver's license, or some other kind of government-issued ID. In addition to that, the third piece of information that needs to be filed for reporting companies that have a CTA filing obligation is information on the company's company applicant. And this is a piece that only applies to entities that are formed in 2024 and afterwards. But the company applicant is typically the person who, in many cases, a lawyer and a paralegal, the people that are actually filing the documents with, in Wisconsin, the DFI to create the new entity.
Great, thank you, Lucas. So now that we've learned what a reporting entity is, the next piece is the exemption and exceptions to that reporting company label. As you'll see from this list, most of the exemptions or exceptions are to entities that have other reporting obligations to the federal government. So publicly traded entities, banks or bank holding companies, insurance companies, accounting firms, utilities. Those entities are exempt because they already have other reporting obligations to the federal government. One exemption that is the tax exempt organization exemption. We've already received a number of questions from tax exempt entities wondering if they are exempt from CTA compliance. The exemption for tax exempt entities states that an organization that is exempt under 501c is exempt from the CTA. Okay, now not everyone knows what code section 501c is, but generally those are public charities and private foundations. The definition is a little broader, but for most purposes, if there's a public charity or private foundation, it is exempt from having to comply with the CTA. Now, oftentimes, public charities or private foundations may lose their tax exemption as a result of, failure to file tax returns or other reasons. if an entity loses its tax exemption, it does have a 180-day grace period to fix that exemption before CTA kicks in, okay? So the other thing to keep in mind for tax exempt organizations is that the exemption to CTA does not apply until a determination letter from the IRS has been received stating that the entity is exempt. So if there is a new tax exempt organization formed who has not yet received tax exemption from the IRS, CTA compliance is still important. So that's just one of the exemptions I wanted to mention this morning. As an example, there are a number of homeowners associations that are not exempt under 501c that, as an example, would have to comply with the Corporate Transparency Act. So homeowners associations need to be very careful to determine why they're exempt or under what provision of the Internal Revenue Code. Another exemption that we want to highlight this morning, actually two, is the large operating entity exemption and the subsidiary exemption. We're going to go through a couple of examples this morning that explain or demonstrate this exemption in detail, because there is definitely a lot of misinformation or misunderstanding of this exemption, and it's very important for people not to just assume that this exemption applies. So let's get into some details. The large operating company exemption requires an entity to employ more than 20 full-time employees in the US, and that is not a full-time equivalent. Many times that where we talk about full-time employees, there's this notion of full-time equivalent. That is not the case for CTA purposes. The definition of full-time employee is actually a difficult situation under CTA. It refers to the definition under the Affordable Care Act. And for those of you that may have experience with the Affordable Care Act, that definition looks at employees or measures full-time employees over a period of time, 12 months, for example. But the CTA looks at the number of employees every day. It's a snapshot in time. So there is difficulty in taking the definition under the Affordable Care Act and applying it to the Corporate Transparency Act. So as a warning, we are recommending that those that are close to this 20 full-time employee number need to get further guidance or have further analysis done on whether or not they actually qualify for the corporate transparency filing exemption, because it's not an easy definition to know whether or not you're in compliance. If you're well over 20 full-time employees, then it's less of a concern. The other requirements are has an operating presence in the US. And then finally, under letter C there, has filed a federal income tax return or information return that reports more than $5 million in gross receipts or sales. And there's a couple of tax return forms listed there, an 1120 for corporations. In that case, consolidated 1120s are acceptable, and all the entities that are reported under the consolidated return benefit from that filing. But as we're going to learn here in a minute, that's the only true consolidated filing that would qualify. Other entities that don't file a consolidated return need to actually file a tax return that reports $5 million in gross receipts. So we're going to see some examples in a minute. The other exception is the subsidiary exemption. If there is a parent company who controls or owns a subsidiary entity, then the subsidiary could take advantage of an exemption, assuming the parent qualifies for an exemption. Also, we are going to see some examples of that. So I'm going to use this very simple model to walk through some examples this morning on qualifying for the large operating company exemption and the subsidiary. So let's get started. Here's our first example. We have a parent LLC that is taxed as a partnership. It files Form 1065 partnership tax return and has over $5 million in gross receipts. and employs 50 employees at that parent company level. The subsidiaries there are on the left, it's a disregarded, wholly owned LLC and has 50 employees. The other two LLCs are disregarded and have no employees. So for purposes of the large operating exemption, this is the result. All of these entities would qualify for an exemption from the Corporate Transparency Act. The parent company qualifies for the large operating company exception because it files a tax return with over $5 million in gross receipts and employs more than 20 full-time employees. The subsidiary entities on the bottom qualify for the subsidiary exemption because the parent, who wholly owns all of them, qualifies for an exemption. So in this example, none of these entities need to file with FinCEN under the Corporate Transparency Act. Here's another example. We have a parent LLC who is taxed as a partnership, files a 1065 with over $5 million in gross receipts, but does not have any employees, appears to be a standard holding company. The subsidiaries here, the one on the left is wholly owned, disregarded, but employs 50 employees. And the other two entities are also disregarded and have no employees. The result here is that all of these entities must file with FinCEN under the Corporate Transparency Act. None of these entities qualify for an exemption. The parent entity does not qualify for the large company exception because it does not employ 20 or more employees. In fact, it has 0 employees. The subsidiary entities cannot qualify for the subsidiary exemption because the parent does not qualify for an exemption, and none of them meet the requirements of the large operating company exception. The entity on the left, actually all of the entities here, do not file an income tax return. The parent files the income tax return, so none of them can meet the exemption. Here's another example. We have a couple of more. This entity can be either a corporation or an LLC that has made an S election. So it's taxed as an S corporation, files an 1120S and reports over $5 million in gross receipts and employs 100 employees. The subsidiaries, the one on the left is a wholly owned single member LLC, disregarded, and has 50 employees. The other two entities, one a corporation, one an LLC, have made qualified subsidiary S elections or Q sub elections, and one has no employees and one has 50 employees. The result here is that none of the entities have to file with FinCEN. The parent entity qualifies for the large operating company exemption because it has over $5 million in gross receipts reported on a tax return that it files and has over 20 full-time employees. The other entities qualify for the subsidiary exemption because the parent is exempt under the large operating company exemption. I have two more examples. This example is very similar to the last one. Again, a corp or an LLC that has made an S election is an S corporation, files 1120S and has over $5 million in gross proceeds. But in this situation has no employees. It is, again, a holding company. The entities, the subsidiaries on the bottom, again, all forms of either disregarded or have made Q sub elections, and some have employees and some do not. The result here is that filing with this Corporate Transparency Act is required for all of these entities. The parent entity does not meet the large operating company exemption, again, because it does not have 20 or more full-time employees. And as a result, the subsidiaries can't fulfill the subsidiary exemption because the parent is not exempt. And they do not meet the large operating company exemption because none of them file an income tax return. That is filed at the parent level. All right, my final example, just to show you, demonstrate that, it's not an all or nothing situation. So here the parent is an LLC taxed as a partnership, over $5 million in gross proceeds, but no employees. It owns 3 entities The one on the left is only owned 50%. There must be another owner. So this is taxed as a partnership. It is not disregarded. So it files its own tax return, has over 5 million in gross proceeds, and has 100 employees. The other two entities are similar to what we've looked at already. They're disregarded. They do not file their own income tax return. It's filed at the parent level, and some of them have employees and some of them do not. The result is a mixed result. The parent company has to file with CTA, with FinCEN for CTA, because it does not have employees. It cannot meet the large operating company exemption. The LLC on the left, that's 50% owned, it does not have a filing requirement with FinCEN because it can meet the large operating company exemption. It files its own tax return as a partnership, reporting over $5 million in gross proceeds, and it has 100 employees. The other two entities on the center and the right would have to file with FinCEN because they do not meet large operating company exception and they do not meet the subsidiary exemption. So those were very simplistic examples of the large operating entity and subsidiary exemption. Obviously, we simplified them for demonstration purposes today, but the analysis can be much more difficult the larger a structure gets and where employees are sitting or being employed versus where a tax return is being filed. Additionally, for everyone who's joining us today, I encourage you to also think about not just an operating structure, but many owners own real estate outside of the large operating entity structure. And those entities that are separate, even though an operating entity qualifies, those real estate holding companies likely will not qualify because they don't employ employees. All right, I'm going to turn it over to Jake now to talk about the definition of beneficial ownership.
Thanks, Amy. So just as a quick recap, a reporting company has certain obligations under the CTA, and specifically, a reporting company must disclose information about the reporting company and about the beneficial owners of the reporting company. So the first question is, who are beneficial owners? CTA defines a beneficial owner as an individual who, directly or indirectly, A, owns or controls not less than 25% of the ownership interest in an entity, or B, exercises substantial control of the entity. So let's first analyze option A, because this one is more straightforward than option B. Under option A, the first example you can think of is you have an individual who owns more than 25% or 25% or more ownership in an entity. This individual will be classified as a beneficial owner. However, you need to take a step further and consider whether this individual is in a marital property state. If the person lives in a marital property state, if they own 25% or more of the ownership interests, and they have a spouse, then that person's spouse may also be a beneficial owner. And then as an example of an indirect ownership under this prong A, an indirect example may be a trust or an LLC who has an ownership interest in another entity. So for example, if a trust or an LLC has an ownership interest in a reporting company LLC, then the trustee of the trust or the managers or members of the LLC would maybe be classified as beneficial owners of the reporting company LLC. So as you can see, this first step, prong A here, is more straightforward. The prong B, substantial control, is a little more vague because, as the definition implies, you need to actually consider a wide variety of circumstances. And so to help with this, CTA has offered some guidance, as you see here. So the first is, it's substantial control would be anyone who serves as senior officer, anyone who has authority over appointment or removal of a senior officer, or majority of the board of directors or similar body, and anyone who has direction, determination, or decision of, or substantial influence over important matters. And for this prong, there is some guidance that CTA has given in the regulations. So for example, here, if you have the power to sell or lease assets, if you have the power over the compensation structure of employees, if you can dissolve or reorganize the entity, these would all be examples under this third bullet point here that would constitute substantial control. And then finally, this fourth bullet point, CTA was basically added this year as a catch-all provision saying that, okay, we have these first three items here to consider, but in the event that we did not cover everything, which of course they inevitably would not, that we have this catch-all provision that is more vague and puts substantial control, which really requires more detailed analysis there. And then moving on to the next slide for penalties for non-compliance. This is an item where, given the novelty of the law, has not been too much guidance from FinCEN because the law just hasn't really had to be enforced too much yet. But what we do know, CTA has provided us with the information that you see here. So someone who willfully provides false or fraudulent information or willfully fails to report complete or updated information may be subject to the penalties that you see here. And it is important to note that ignorance is not a defense here. Next, let's consider if you file the report, but maybe you have a mistake on the report. There is a 90-day safe harbor to voluntarily correct such a mistake. And then moving on to the final item I'm going to talk about today is dissolution. So dissolution, the main rule to consider here is, was your entity in existence in 2024? If it was in existence, then your entity is subject to the CTA. However, you would not be subject to the CTA if your entity was formed before 2024 and if it was dissolved before 2024, then it would not be subject to CTA. And now I'm going to pass it back to Amy to talk about some practical considerations.
Great, thanks, Jake. Okay, so now that we've kind of had an overview of the Corporate Transparency Act, what a reporting company is, exemption or exceptions that may apply, the definition of beneficial owner, we're going to talk about now the steps for compliance. So we're going to talk about determining your filing obligations, identifying beneficial owners, obtaining the beneficial owner information, initial report filing, and then updates and changes. Okay, so the first few steps are pretty obvious. Is the entity a reporting entity? Lucas talked through a reporting entity is an entity that files with the state, whether it's the Department of Financial Institutions in Wisconsin or the Secretary of State in other states, those business corporations, non-stock corporations, LLCs or limited liability companies, LLPs, any of those entities are reporting companies. The next step is certainly figuring out whether an exemption or exception applies. As we walk through, the most challenging one is probably going to be that large operating entity and doing an analysis on whether or not you actually meet the requirements there. So let's pretend for a second you've done those two steps and you've determined that you have a filing obligation and you don't meet any of the exceptions. What is the next step? The step is to identify your beneficial owners. Jake went through the definition. So the first step is looking at your ownership structure, looking at ownership percentages, looking at equity awards. It's somebody who controls or owns not less than 25%. So it's beyond just pure ownership, and it's directly and indirectly. So the emphasis is on individuals. So if somebody owns something through a trust, you have to review the trust and determine, is it one or more trustees, or is it a beneficiary, or both, or all of the above that have to be reported as beneficial owners. Additionally, you have to look at the organizational documents, articles, bylaws, operating agreements, shareholder buy-sell agreements. You need to determine if anybody has substantial control. Does anyone have the ability to name a board member or has veto rights on a board member? The other business agreements or documents, voting trust, employee agreements. Is there a high-level officer who has some of that substantial control, like Jake talked about, over finances or business decisions, business lines, geographic area. The definition is pretty broad. So it requires an in-depth review of how the business is operating, not just the named owners. And then finally, I kind of mentioned this at the beginning, looking at those voting trusts or irrevocable or revocable trust documents. Again, the emphasis here on the beneficial owner is it is an individual or individuals. And so you need to undertake an analysis to determine, hey, if there's a trust owner here, again, is it one or more trustees? Is it beneficiaries that have to be reported, or all of the above? All right. Once you have determined that you have a filing obligation, an exemption does not apply, and now you know who your beneficial owners are, you have to start gathering your beneficial owner information, or BOI, we call it BOI, BOI, and those are legal names, dates of birth, residential addresses, and then copies of those government issued IDs. Not only do you have to input, information on those IDs, but a copy also needs to be uploaded as a part of the filing process. And filing the initial BOI report. So here is the link to the BOI filing at FinCEN. I've taken a little screenshot there of the top portion of the form. I will caution all of you that the form is not exactly intuitive. It is a PDF form that does get updated and does change. You'll see there in my little screenshot, this one, the current one was released on April 5th. It's had number of revisions and updates since it went live in January. But it's a PDF that you download, and then you have to go through the steps there that are listed on that screenshot to enter information and also embed copies of those government IDs. One of the more challenging pieces of CTA, if it's not the definitions and meeting exemptions or who's a beneficial owner, it is this ongoing compliance issue. So once a report has been filed, any information that changes on that report must be updated and reported to FinCEN within 30 days of that change. So if you have a change in ownership, if somebody's trust document changes, who is an owner, somebody moves and has an address change, somebody gets a new driver's license or passport issued because it expired, or if there's a loss of exemption, all of those changes need to be reported within 30 days. I know many of you are probably familiar with, Wisconsin's Department of Financial Institutions, the DFI, that annual report. I know many of us have received those. I think they're blue or green cards that remind us of the annual filing. And now those are going to be, those reminders will be sent via email. But for CTA purposes, it is not an annual filing. You will not receive an annual reminder. It is an ongoing compliance requirement that if anything changes, you must file an updated report within 30 days of that change. Finally, I'm just going to review here the filing deadlines. Entities that were created on or after January 1, 2024, your initial report is due within 90 days of formation. Okay, this is something that is in effect for 2024, that 90 days. Starting in 2025, that will be reduced to 30 days. So any new entities created will have currently 90 days, but starting in 2025, will have 30 days to file with FinCEN. Entities created before January 1 of this year, an initial report is due by the end of the year. It must be filed before January 1 of 2025. And again, changes or updates are due within 30 days. So if you work hard to file next month, your update obligation starts. Anything changes, you have 30 days to update. Okay, so let's talk about the current legal landscape right now. If you've been paying attention to some news out there, there's definitely some challenges or discussions around the Corporate Transparency Act. So I just want to go over those and fill you in on what's currently going on. So on March 1st of this year, a federal district court in Alabama ruled that the CTA, the Corporate Transparency Act, is unconstitutional on the basis that it went beyond Congress's legislative powers. Okay, but that ruling only applied to the plaintiffs in that case, which is the National Small Business Association. And it only applies to the members of that association as of March 1st. So there were thoughts that people could maybe sign up for a membership with the National Small Business Association and then qualify for this ruling, but that is not the case. It only applies to the members of that organization as of March 1st. That means everyone else, CTA is still a requirement. It has not been ruled unconstitutional for everyone else. On March 11th, FinCEN did appeal that federal district court judge's ruling, and it's now being reviewed on an expedited basis by the U.S. Court of Appeals in the 11th Circuit. And who knows, this could go all the way to the Supreme Court. If you look at the commentary out there, people are suspecting that CTA may get to the Supreme Court yet this year, this fall. That would be very quick in terms of legal review and appeals, but obviously this is a big piece of legislation that impacts the entire country. And I will caution you also that even if the CTA ends up being overturned, it could easily just be sent back to Congress for a simple fix to make it comply with Congress's powers. And so I don't think that a judge's ruling at this time that's going to be the end for CTA. I think this is going to continue being something that the federal government keeps trying to enact and enforce. Since that ruling on March 1st, there have been other cases filed throughout the country. One of them that I'm kind of following is on March 26th, the Small Business Association in Michigan and a Chamber of Commerce also filed in the Western District of Michigan to same request, wanting the judge to find the CTA to be unconstitutional. If that ruling comes out, favorable to the plaintiffs, FinCEN is likely also to appeal that to the 6th Circuit Court of Appeals and so forth. So we may have multiple avenues to the Supreme Court here on CTA. As I said earlier, despite these legal challenges, the best course of action is to prepare for compliance. Nobody wants to get caught in the month of December not having been prepared for this filing and then be scrambling to do so. So we are encouraging everyone, you need to start thinking about this now and start preparing to file or consider filing before it gets too late this year. Jake, Lucas, and I are a part of a much larger team at Rooterware that's assisting with analysis of the CTA requirements and how they apply to our clients, as well as assisting with filing reports. We are available to assist, but I want to make it very clear that we certainly are going to help our clients with this, but it's on a first come, first served basis. Because this piece of legislation is so new, there are very few people out there willing to provide guidance and assist with filing. Many attorneys are not willing to take this on because it is a new piece of legislation that has lots and lots of questions. I'll just give you a quick example of one of those questions because I follow lots of listservs that are going on and questions being posed to FinCEN, but one of them is, there is a 103-year-old woman who is a beneficial owner of an entity. She is in assisted living of some sort, does not drive, and has no government-issued ID. She's 103. She does not drive. She does not have a passport. And so does somebody really need to take her to the DMV to get a government-issued ID so she can comply with CTA? So that's one of the many questions that are being proposed that we just don't have answers to. And there are many more. So again, please think about these obligations. Do not wait until December. I think these are here to stay. And again, if you have any questions, please reach out. And thank you so much for joining us this morning. We hope this was informative and helpful in understanding the Corporate Transparency Act. Thank you.